Good afternoon, everyone. Thanks very much for joining Muckle LLP's web seminar. Title of the presentation, 10 cases every insolvency practitioner should know. That's in our opinion, but we've picked out what we think are the cases worthy of note over the last 12 to 18 months. We have had some technical problems with the live web seminar that we intended to carry out this afternoon. We do very much apologise for that. It was circumstances that were entirely beyond our control. We asked for the phones to be muted on a number of occasions, and we tried to use the software to arrange for those phones to be muted ourselves. Unfortunately, there was an issue that we could not overcome, so we had to cancel the seminar. What we've done, though, however, is we've decided to record the presentation in the hope that you do find the time to actually arrange to dial in and listen to what we have got to say and present to you this afternoon. I'm going to move through the slides now. There is one now that talks about muting the phone. That's obviously not necessary anymore, but nevertheless we will move on to the first case. Myself and Kelly I'm a partner in Muckle LLP. I head up the firm's restructuring legal team. I'm a member of R3, the Turnaround Management Association and the Insolvency Lawyers Association. I'm also board director of the Turnaround Management Association. My colleague Kelly Jordan is a solicitor working alongside me in the restructuring legal team. Kelly's a member of R3 and she spent some time working as a secondee with the Royal Bank of Scotland, GRG. The first case that we'd like to present to you this afternoon is the Eurosale case, which many of you will have heard of and come across in practice. This is the courts grappling with the concept of balance sheet insolvency, having regard to the real-life events of the crash of 2008 and the impact that that has on the overall assessment of an enforcement event in the context of loan notes. Essentially what happened here is that the company purchased a portfolio of subprime mortgages. The purchase itself was funded by issuing loan notes in various classes and currencies, with the vast majority of the loan notes repayable in 2045. In terms of the income from the underlying mortgage assets, this was expressed to be payable in sterling, yet the notes were payable in US dollars, euros and sterling. As such, it was necessary for Eurosale to enter into currency swaps. Principally, those currency swaps were placed with Lehman Brothers, which would provide in the event of default for all of the loan notes to become payable. The currency swap protection was an absolutely vital element of Eurosale's protection, and that currency swap protection was lost on the insolvency of Lehman Brothers. In view of all of the above, plus adverse moves in interest rates and currency rates, and the poor performance of the mortgage market, the question of the company's ability to perform and pay interest on notes and repay principal to the extent that funds were available was considered. What we actually had was a group of junior loan note holders who were trying to improve their overall position. They had thought that they would suffer a shortfall if in the event of default, and as such they were looking for a default. The reason for that is that would enable them to rank pari passu with the senior loan note holders. That was going to be a better position for them than if the company was able to carry on trading, servicing its liabilities over the 30-year period until the maturity of the loan notes. They issued an application at court and tried to basically look at the concept of whether or not balance sheet insolvency could be called as an event of default. The Court of Appeal first heard the case, and we first started to hear the concept of the point of no return test, which was judicial parlance that came out of the Court of Appeal. The Supreme Court has subsequently looked at the case and determined that there is a much broader concept here than the point of no return, and has emphasised that that should not form an entire part of the interpretation of balance sheet insolvency. In other words, let's not substitute point of no return for the overall test of balance sheet insolvency in the Insolvency Act itself. The court looked at what they considered were three imponderable scenarios. They looked at what they considered the currency movements were likely to be over that 30-year period, together with interest rates and the general economy. That look-forward period was the bit that could not form part of any scientific analysis. It was really only a matter of speculation to look at what might happen over that period. The court basically has said, let's be very cautious indeed in deciding whether or not a state of balance sheet insolvency exists. There is a broad consideration of all of the available circumstances to allow for a judicial determination as to whether or not such an event has occurred. This in itself has broad application in the vast majority of contractual documentation where we're looking at insolvency as an event of default. We've started to work with some of our corporate finance and commercial colleagues to look at the potential to consider redrafting termination provisions in our contractual documentation to have regard to this most recent Supreme Court authority. What we're going to do now is move on to the Nortel case. The Nortel case is one that has been in the eye line of a vast number of practitioners now for several years. Essentially, what happened in the Nortel authority is that we had what was considered to be a rather worrying extension of the class of expense creditors in an administration. In this particular case, what was originally thought and held to be the case was that the pension regulator's moral hazard provisions would basically enable a financial support directive issued after the appointment of an administrator to rank as an expense claim in the administration. What that meant in practical reality was that the expense claim, the financial support directive itself, achieved a level of priority, a level of super priority that was over and above what was originally envisaged and thought to be the case, that financial support directives should be determined to be simply provable debts in an administration. In other words, they sat in the pot with all of the other unsecured creditors. In terms of the ability of an administrator to extract his remuneration from the floating charge assets, they were inevitably constrained by the fact that the expense claim meant that they could not extract their remuneration in the usual way. The simple value of the level of financial support directives in any given case was likely to entirely absorb the total amount of recoveries under the floating charge and created a real practical problem for practitioners trying to run their cases. The pensions regulator tried to sort of reduce some of the impact of this by issuing guidance notes to the effect that they would not object to any application made by a practitioner to have the interest in the floating charge subordinated behind the administrator's remuneration. However, an administrator who was effectively not able to withdraw any remuneration is going to find it extremely difficult to embark upon court proceedings to try and resolve their problems in this regard. The take-up of those kind of applications is questionable, and certainly we would be interested to hear from any practitioners who have taken it upon themselves to make an application at the relevant time. Moving this case onwards through to the Supreme Court, the key question for the court was to consider where in the order of priorities of payment those liabilities under the moral hazard provision should sit. There was a unanimous decision of the Supreme Court which held that such financial support directives issued after the date of the administrator's appointment were not expenses, as had previously been thought, but rather that they were provable debts within Rule 13.12 of the Insolvency Rules. The key focus here was for a consideration of the fact that such companies had already the key focus here was the consideration of the fact that at the date the administrator was appointed, the company itself was already obligated to make a payment to the Pension Protection Fund, and as such the financial support directive was a liability arising under an obligation to which the companies were already subject at the date they entered into administration. The liability to make that payment was pre-existing, and therefore there was no justifiable reason why they should be considered to be expense claims in the usual way. My colleague Kelly is now going to pick up a series of employment-related insolvency cases that we've picked out as being ones that practitioners should have regard to. And I'm now going to hand you over to my colleague Kelly, who's going to review and run through those cases with you.
Thanks, Andrew. I've got a handful of cases here which have produced a mixed bag of results for employees and office holders. Kick off with the first one of McDonough and others and Pengelly and others, both of which involved employer companies which had entered into a company voluntary arrangement prior to ultimately entering into compulsory liquidation. In both of those cases, the employment appeal tribunals had held that the employees who were employed by a company in those circumstances, i.e. one which had gone into a CVA and then subsequently into liquidation, were not entitled to payments out of the National Insurance Fund when at the point at which the company entered into liquidation. The background to these cases were that the employee's employment had effectively terminated at the point of liquidation. The affected employees had made claims in the National Insurance Fund for arrears of pay and for unpaid holiday pay. Their claims were rejected by the National Insurance Fund on the basis that they weren't entitled to any such payments, since, unbeknown to them, the company was already subject to an insolvency event by virtue of the fact that their employers had previously entered into company voluntary arrangements. The employees obviously objected to that decision and submitted claims in the employment tribunal, and at first instance those claims were upheld. Secretary of State appealed the decision, and the Employment Appeal Tribunal was forced to consider the provisions of the Employment Rights Act, specifically Section 182, which deals with this specific issue. What Section 182 says is that a payment should be made out of the National Insurance Fund if an employee's employer becomes insolvent and that their employment is terminated, and that at the appropriate date the employee is due a payment from its employer of a nature which is the subject of this particular section of the Employment Rights Act. The Employment Appeal Tribunal was, in consideration of that, was forced to look at Section 183 of the Employment Rights Act, which confirms that a company voluntary arrangement would fall within the definition of insolvency for the purposes of the Act. And also, under Section 185 of the Employment Rights Act, the appropriate date for arrears of pay and holiday pay is deemed to be the date of insolvency. So, considering all of that, the Employment Appeal Tribunal held that the legislation provided for there to be only one insolvency event. There couldn't be multiple events. It confirmed that liquidation would be a separate event and would be the relevant event where it had not been preceded by a company voluntary arrangement, but where it was preceded by a company voluntary arrangement, it had to be the earliest of those insolvency processes that was the relevant event for the purposes of the Employment Rights Act. Additionally, the appropriate date is the date of the actual insolvency event itself. That's a single date, and the law doesn't provide for there to be multiple dates. In this case, the Employment Appeal Tribunal held that the appropriate date was the date the CVA was approved by the court, and logically following that through, arrears of holiday pay and arrears of pay falling due after the date on which the CVA was approved would be irrecoverable from the National Insurance Fund. I think it was acknowledged by the Employment Appeal Tribunal that that was clearly not the best outcome for employees and not necessarily the fairest outcome for employees, but it came to the conclusion and justified its decision on the basis that it wasn't the Employment Appeals Tribunal to plug any gap or hole in the legislation, and it was forced to follow the law as it had. Turning to the next case is iLab Facilities Limited. In this case, the Employment Appeal Tribunal had held that a sale of only one part of the business would not render those employees employed in the remaining part of the business to be affected employees for the purposes of CHIPI. In this case, there had been a sale of only part of the business. The remaining part of the business was closed down, and the Employment Tribunal was forced to consider whether employees employed in the part that was closed down were deemed to be affected employees for the purposes of CHIPI. That's important because only employees that are affected by the transfer need to be consulted for the purposes of CHIPI. In this case, the employer was facing insolvency. The company had intended to sell its entire business, but ultimately the liquidator was only able to secure a sale of part and was forced to close down the remaining parts of the business that weren't sold. The employees in the remaining part of the business were automatically dismissed, and those employees brought proceedings in the Employment Tribunal for various things, including a claim for failure to inform and consult, which is required under Regulation 13 of CHIPI. By virtue of Regulation 15 of CHIPI, both the employer company and the transferee to whom employees are transferred are jointly liable for any failure to inform and consult, and therefore the employees brought claims against both the company, which was in liquidation, and the transferee company. At first instance, the Employment Tribunal upheld the employees' claims, holding that the dismissed employees were affected employees by virtue of the fact that they were excluded from the transfer when, as was originally anticipated, they were intended to be included in the sale. The transferee appealed that decision, and ultimately the Employment Appeal Tribunal reversed the decision and held that in terms of the transfer as it ultimately happened, that is the transfer of the part of the business which the claimants were not employed in, the indirect impact of that was not such as to render those employees affected employees for the purposes of CHIPI. The Employment Appeal Tribunal also clarified that ultimately, in terms of the earlier intended transfer of the whole of the business, then no claim could be brought in respect of that transfer, since it had not actually taken place. An employee can only bring a claim where the transfer does take effect. I think this provides some positive news for office holders and the rescue culture generally, in the sense that hopefully the decision should not put off prospective purchasers of ailing businesses in fear of them being sued for any failure to inform and consult with any employees that are left behind as part of the transaction. The next case, also some relatively positive news for the rescue culture generally. The case of AEI Cables, where the Employment Tribunal was required to consider the obligations under Section 188 of the Trade Union and Labour Relations Consolidation Act 1992, which also lays down a requirement of employees to inform and consult where redundancies are proposed to take place. And the Employment Tribunal also considered the use of protective awards where there has been a breach of those obligations. Section 188 of the Trade Union and Labour Relations Consolidation Act effectively provides that where there is a proposed dismissal of 20 or more employees, there is a requirement on employers to collectively consult with representatives of any affected employees. That consultation needs to be timely, and where the proposal is to dismiss 100 or more employees, the consultation period must commence at least 45 days before the first dismissal takes place. If there is special circumstances which makes it not reasonably practicable for an employer to comply with those obligations, then he must still take all steps that it's reasonably practicable for him to do so in the circumstances, which you might think would provide some leeway in terms of an insolvency situation. However, the courts have consistently held that insolvency is not in itself a special circumstance for these purposes. Just looking at the facts of this particular case, the employer company was in financial difficulties and sought advice from professional advisors from a firm of accountants. Their accountants advised that unless the company was able to reduce its costs substantially and or to secure additional funding or finance from its lenders, then there was a real risk that the company would be deemed to be trading insolvently, which would thereby bring about the prospect of the directors of the company being personally liable for wrongful trading. Shortly after the company received that advice, the company's bankers withdrew its support and indicated that it wasn't prepared to provide any further finance to the company to support it. In those circumstances, the directors felt that they were left with no other choice really but to take immediate steps to close down one of its plants. And immediately after making that decision, a representative from the company notified a union rep that that was the intention, and the following day a number of employees were dismissed as redundant. Those employees that were dismissed brought claims in the Employment Tribunal which held that there had been a complete failure on the part of the employer company to inform and consult with the affected employees, and the tribunal ordered the maximum award of 90 days pay for each employee. The company appealed the decision. Whilst there was no arguments raised by the company in terms of whether or not the insolvency of the company rendered it a special circumstance for which that they didn't need to comply fully with their obligations, nor did they sort of seek to argue that there had actually been an attempt to inform or consult with employees. What the appeal turned on was the actual quantum of the award that was made in the employee's favour. The Employment Appeal Tribunal agreed with the company and felt that the Employment Tribunal in the first instance hadn't considered the mitigating factors, which essentially meant that the company couldn't possibly continue to trade in its current financial circumstances simply in order to allow it time to comply with its obligations to inform and consult with its employees. The Employment Appeal Tribunal stressed that the purpose of a protective award is a penal measure and not compensatory in nature. Its purpose is to ensure that employers comply with its obligations. The Employment Appeal Tribunal felt that where there had been a complete lack of information provided to employees and a lack of consultation, then the tribunal should start with the maximum award and reduce it where there are mitigating circumstances, and that it should be reduced to the extent that the tribunal feels is necessary and reflects the circumstances in that particular case. In terms of the particular facts of this case, the Employment Appeal Tribunal felt that the employer was not, the actions taken by the employer were not one of a company flouting its obligations. It was simply trying to keep the union rep updated in very difficult circumstances. Ultimately, the Employment Appeal Tribunal held that it would be unreasonable to expect an employer to trade whilst insolvent to enable it to consult with its employees, and that ultimately the protective award should be reduced accordingly. And the final case that I'm going to look at is the Ethel Austin case, which also considered Section 188 of the Trade Union and Labour Relations Consolidation Act, which we've just discussed there. It looked at it from a slightly separate angle, specifically in terms of the meaning of at one establishment within that section. Section 188 actually provides that where an employer is proposing to dismiss as redundant 20 or more employees at one establishment within a period of 90 days or less, then the employer must take steps to inform and consult with those employees. The key question here, therefore, was what was actually meant by at one establishment. The case itself concerns the two retail cases of Ethel Austin and Woolworths, which commenced with an administration followed by liquidation of those two companies. And in both cases, employees that were made redundant from those companies with little or no consultation were awarded protective awards where they worked at a shop which had 20 or more employees. Those that worked in shops with fewer than 20 employees were not given any award whatsoever. The union appealed the decision in which the protective awards were made, and the Employment Appeal Tribunal looked at what this meaning of at one establishment was, and whether the employees that worked at stores with fewer than 20 employees should have in fact been awarded a protective award as a result of their lack of consultation. Ultimately, it was held that the only way to interpret the provision in order for it to sit comfortably with EC regulations was that the actual phrase at one establishment should be disregarded for this purposes. This meant that employees at the smaller stores were also entitled to collective consultation and should have been made a protective award. I'll just hand back now to Andrew.
Thanks very much, Kelly. The next case we're going to look at is Data Power Systems Authority, which is an interesting case, and it serves to demonstrate some of the problems that can exist when creditors pursue their right under Schedule B1 of the Insolvency Act to persuade a court to appoint an administrator. The facts of this case were that a company was set up and incorporated to establish and operate a data centre. It was a capital expenditure project which quickly failed quite soon after the commencement of the company for various reasons, leaving a bit of a sour taste, and the company having few assets but significant liabilities to trade and other creditors. The situation was that there wasn't any secured creditor on this one, and the business itself had no employees. The question really was what could be done to salvage the mess, and some creditors came together and determined that it would be appropriate for them to apply to court and seek to appoint an administrator. And the proposed administrator effectively certified that the statutory purpose in this case was capable of being met, in that he felt that a better return would be provided than if this case was simply one where the company entered into liquidation. What seems to have compounded the court's troubles with this case is that a further creditor sought to join into the proceedings and appoint a separate insolvency practitioner. Both insolvency practitioners came forward and said they felt the statutory purpose could be fulfilled. What they didn't do, however, was provide the court with any meaningful evidence it could consider to determine why they thought that was the case. What seems to have emerged here is a sort of twin-track process for the level of information that an insolvency practitioner has to put before the court. Of course, in the out-of-court appointment process under paragraph 22, and indeed under paragraph 14 for a floating charge holder appointment, most practitioners will be used to signing off the statement of demonstrating their acceptance of the appointment and also confirming that they are satisfied that the statutory purpose in this case is capable of being fulfilled. They don't tend to operate on any more than simply signing off the document. I think what seems to have occurred in this case is that there was a perception formed that it would be sufficient to do likewise in a fully blown application before the court, particularly one where there was counsel appearing to seek to make representations for two separate and competing appointments. The judge was similarly not satisfied with that lack of information before the court. The court was then tasked with considering what it should do to try and move the situation forward and provide a just result. The court instead looked to its powers to treat the hearing itself as if it were a hearing to wind up the company, which is the default position for anybody seeking to appoint an administrator through the in-court process. The court can ultimately determine that it's not appropriate to grant an administration order. It can, of its own motion, of its own volition, seek to wind up the company at that stage. The court didn't elect to wind up the company automatically at this stage. What it elected to do was seek to, of its own motion, appoint a provisional liquidator. It seemed to be motivated to do so simply by reference to the fact that there wasn't enough in the application to justify the administration. What this case then serves to do is act as a real reminder for all practitioners that there must be clarity in regards to what they are putting before the court, together with underlying evidence of why they say what they are saying. A simple assertion that the statutory purpose is capable of being fulfilled is not enough. They must go beyond that, and that's even the case if they're attaching their professional reputation to it by putting their name forward as being willing to accept the appointment. The judge will not accept that, and in most cases will require something much more. We're going to move on now to the case of Bramston and Holt, which is an interesting case. What happened here was that there was an undischarged bankrupt, a bankrupt who had not sought to take steps to comply with his obligations to his trustee, and one which the trustee felt had effectively attempted to be dilatory in the provision of information and had sought to conceal assets and effectively not be as forthcoming and compliant with his duties to his trustee as he should have been. What then happened was that the bankrupt himself sought to try and move forward to exit the bankruptcy into an individual voluntary arrangement and thereafter seek to annul the bankruptcy. Most practitioners will be aware that it's only possible to do this whilst the bankrupt remains undischarged. Once the bankrupt has been discharged, he loses the opportunity to seek to exit the bankruptcy into an individual voluntary arrangement and seek to annul the bankruptcy as a result of that exercise. It's absolutely vital that he works to the timelines envisaged by the Insolvency Act, being a year from the date of the bankruptcy order being made. The bankrupt in this case sought to utilise the provisions of Section 279 of the Insolvency Act. Practitioners will be aware that Section 279 is the provision that is often utilised to try and act as a penal measure to effectively drag the bankrupt forward and get him to cooperate with his obligations to his trustee. Essentially what there is here is effectively two limbs to the test of whether Section 279 is applicable. The first limb is that you have to be demonstrating to the court that there is at least an attempt not to comply with your obligations to the trustee. In almost all cases, it's going to be the trustee himself who's making the application. What makes this case really unusual is the fact that the bankrupt sought to bring the application to 279 because what he wanted to do was to buy himself more time. He wanted to make sure there was enough time available in the timelines to make sure he could apply for his individual voluntary arrangement. Not surprisingly, the trustee was not happy at this scenario. He was not happy at being manipulated by the bankrupt, and he sought to object to the application to Section 279. The case was then determined by the court, and basically the court determined that it was not appropriate for the bankrupt to utilise Section 279 in this way. The bankrupt was directed that he may have considered an application for a simple stay of proceedings, which could have had the desired effect, although the court was careful not to want to say that it would have done so. I'm now going to move on to the case of Davis and Price, which is an interesting case involving debtors who sought to apply for individual voluntary arrangements. Mr. and Mrs. Price were creditors of Mr. and Mrs. Davis for an unliquidated sum. Mr. and Mrs. Davis proposed interlocking individual voluntary arrangements. Price put a claim in at a creditors' meeting to consider the debtors' proposals. What then happened was the supervisor of the first creditors' meeting determined that the claim that had been put forward by the creditor should be valued at £1 for voting purposes. The IVA was then approved at the first creditors' meeting. The creditor then determined that this gave grounds for an application to challenge the outcome of the creditors' meeting as a material irregularity, and then sought to bring his and her case before the court. The court looked at the case and did determine on the merits that there was a material irregularity. What then happened was that the debtor was directed to call a further meeting of creditors, at which he had the option to put forward fresh proposals or to revise the original proposals. The debtor then called the second meeting, at which case the creditor then submitted a further claim to include all of his overall liability, save for the costs of commencing the material irregularity application. The IVA was approved at the second meeting, and crucially the provisions for the creditor's costs were not included within the creditor's claim in the IVA. What the creditor was trying to do here was to preserve his opportunity to recoup his costs outside of the arrangement. The creditor then moved on to submit a statutory demand for payment against the debtor, attempting to sit outside of the IVA and seek to provoke payment of the costs which had been incurred in the pursuit of the material irregularity application. Subsequently, the debtor then applied to set aside the statutory demand, basically arguing that the costs had and should have been wrapped up in the IVA. The court then looked at the question of what had occurred here and did agree with the debtor that the costs should have been included within the second claim. What the creditor was trying to argue was that he could not possibly be bound by this because he could only be bound by those creditor claims which existed as at the date of the first creditors' meeting. He wasn't concerned about what had occurred subsequent to that date. The court didn't agree with that approach and subsequently ordered that it was right for the statutory demand to remain set aside and that all of his costs were wrapped up in the IVA. The final case I'm going to deal with is the case of Appleyard. And I'm going to say Appleyard versus W, primarily because I don't know how to pronounce the name of the case. Some of you might want to have a go at that in your own time. What happened here was that there was an application made following a bankruptcy order that was originally made on the 20th of April 2011. This was following a bankruptcy petition which had been presented by a factoring company against the debtor. Initially, the bankrupt sought permission to appeal the making of the bankruptcy order, and such permission was initially refused. The trustee in bankruptcy was then appointed, and the bankrupt thereafter made an oral application to appeal the making of the bankruptcy order in a slightly unusual twist, the appeal or permission to appeal having already been refused. Such permission was granted, and the trustee was notified of the hearing date for the appeal hearing through the bankrupt solicitors. At that hearing, the judge then granted an adjournment and effectively relisted the matter to be heard on the 14th of December 2011, at which the bankruptcy order was set aside. For various reasons, the trustee had not received notice of that revised hearing and did not take part on the day. As such, there was no submissions put before the court as to how to deal with the trustee's remuneration or expenses, the trustee not being there having received no notice. Subsequent to that, the trustee then basically found out about the case, and thereafter what happened was he sought to look at the overall situation, and the trustee applied for directions in the High Court. The High Court directed that the trustee should be released from office with immediate effect, and more significantly, the trustee was also entitled to recover his expenses. However, he was only entitled to recover his expenses up until the date he received notice of the fact that the bankruptcy order had been set aside. He was not entitled to recover any expenses for any work done after that date in terms of any further statutory reporting or preparation for any further hearings. What this case does is highlights the importance of dealing with and being mindful of the position regarding trustees' expenses in the course of bankruptcy proceedings, and demonstrates the ambiguities that in the existing legislation and the various pitfalls that can befall a trustee in dealing with this particular line of work. That's the end of the 10 cases that we wanted to present to you today. I'm very grateful to you for listening into this web seminar. I'm sorry that we did encounter difficulties running it live, but I hope that you found this recording useful. We are going to look at providing you with some follow-up information, including a copy of the slides and including a copy of some follow-up material as well. There's a big question mark here for any questions. Obviously, there's nobody there that can ask us questions at this stage. However, what I've done now is I've attached to the back of this presentation various ways and means which you can join in with Kelly and I and the team at Muckle LLP to take part in the discussion. We have set up and established a very popular and lively group on LinkedIn. We have over 2,000 insolvency practitioners and restructuring experts on a worldwide basis, include members of the turnaround community, restructuring community, bankers, invoice discounters, venture capitalists. It's a very popular meeting place for people online to debate topical issues between themselves. I'm aware that many of you will be on LinkedIn, and I would be grateful, as would Kelly, to receive any invitations from anybody who wants to join in with our network and seek to improve the overall experience. Please also consider joining the group as well. There's also methodology around joining up with us via Twitter. I regularly tweet industry updates through the @Company Rescue handle. We've noted down our email addresses there and our telephone numbers. And finally, in a twist of technology, there is also the ability to contact me by FaceTime. If you want to have a go at that, please feel free. As I say, thank you for joining us today. I do once again apologise for the difficulties with the live experience, but I am very hopeful that we can rerun this and further web seminars moving forward. In order for us to be able to do so, it would be very useful for you to provide any feedback on this recording and whether or not there are any topics that you might be interested in us running. We're more than happy to put the time in and invest in preparing the presentation and the material, and to provide opportunities to increase the interaction between ourselves. In order to do so, we just need to hear back from you and hear what you would like us to present on. Once again, thanks very much for joining us today, and I'm going to sign off this web seminar now. Thank you very much.
Thank you.